Hello everyone and welcome to week 4, day number 1. So this week we are dealing with 2 chapters again, chapter 3 and chapter 14. Chapter 3 is going to be discussed in this day 1 video, and then chapter 14 will be discussed in the day 2 video. So chapter 3 is getting us started on discussing medical law and ethics, as well as HIPAA. Medical law and ethics has 4 different classifications or categories that it can be broken down into. The 4 are criminal law, civil law, international law, and military law. Now, only 2 of these categories really are going to relate to the medical field, and those 2 are the criminal and civil laws. So that's what I will focus on more for this video, but I do encourage you to read through your book and read on international and military laws. So we're going to start with talking about criminal laws. Now, criminal laws are laws that were made to protect individuals and the public as a whole from harmful acts of others. When we talk about criminal laws, they fall into 2 categories. The 2 categories are either felonies, or misdemeanors. A felony is an act that can carry punishment of either imprisonment in a state or local prison or the death sentence. Some of the felonies that you might know of are things like murder, rape, robbery, or as it relates to the medical world, practicing without a license. Misdemeanors are less serious offenses. They carry a punishment of either fines or imprisonment for up to a year. Some examples that you might know of for misdemeanors are that of traffic violations, disturbing the peace, or theft. Now, when we start talking about criminal laws, a physician's license is something that can be taken away or revoked if they commit a crime. For example, they could commit crimes such as sexual misdemeanors or misconducts, murder, or violation of narcotic laws. But we as medical assistants do not have a license, so that means that we work under a physician license. This means that because we work under that physician license, we cannot diagnose our patients. We still need to leave that up to the provider. If you are trying to diagnose or treat a patient, you can also be fined and prosecuted even though you do not have that license. So please make sure that you understand that just because you work under a physician license, it does not make you a physician, and you cannot diagnose your patients. Civil laws are the next one we're going to look at, and when we talk about civil laws, they are laws that concern the relationship between individuals or between individuals and the government. Civil laws can further be broken down into 3 categories. They can be tort laws, contract laws, or administrative laws. So let's take a few minutes and go ahead and look at each of those individually. Tort laws are laws that cover acts that result in harm to another. In the medical world and medical law, this means that you must cause damage or injury to the patient in order for it to classify as a tort law. It must be an injury or damage caused by the patient or an employee of the physician, such as that of a medical assistant, nurse, phlebotomist, something to that effect. And when we talk about tort laws, the charges are either defined as intentional torts or unintentional torts. Intentional torts mean that you perform an act intentionally without your patient's consent. For example, causing assault, battery, false imprisonment, defamation of character, fraud, or invasion of privacy. On the opposite side, an unintentional tort could be labeled as something like neglect or negligence. Now, in order to prove that negligence has occurred, the defendant will have to prove the 4 Ds were present. The 4 Ds of neglect are called duty, dereliction of duty, damages, and direct cause. And you can read more on those within your book and in this chapter. The second type of civil law is a contract law. And contract laws are laws that include enforceable promises or agreements between 2 or more persons to do or not to do a particular action or service. So technically, when you come into a doctor's office and you agree to see them and they agree to see you, that is essentially a contract law. Okay? It may not be that you actually write out a physical contract, but it does fall under this type of civil law. Now, a contract between parties must be composed of 4 parts in order for it to be considered an actual contract. Those 4 parts are an offer, an acceptance, a consideration, and a competency. Now, all 4 need to be present in order to make that contract legal, as I stated. And the last type of the last type of civil law that we have is administrative law. This covers regulations that are set forth by governmental agencies. Most healthcare employees are more frequently going to be dealing with contract laws or tort laws, so we don't touch too much on the administrative law. But one of the main administrative laws that fall under this type are things if you violate HIPAA, or if you can complete or you actually perform some sort of Medicare fraud. All right, and one other part of Chapter 3 that I think is extremely important to discuss is malpractices. Now, malpractice is an unreasonable lack of skills that result in an injury, a loss, or a damage to a patient. Malpractice claims are classified into 3 types. They are either a malfeasance, a misfeasance, or a nonfeasance. Malfeasance is when you perform a wrongful act or an unlawful act. Opposite of that is when you have misfeasance. You perform a lawful act but not in the proper way, and it causes that injury or harm to a patient. The best example I can come up with for misfeasance is if you go into a surgery and your right leg, let's say, is supposed to be amputated, but when you wake up, the left leg is amputated. They performed a lawful act, they had your permission, but they removed the wrong body part. They did it in an improper way. And nonfeasance means that you are neglecting or ignoring or refusing to perform a necessary lawful act. So, for example, if a patient comes in and they are a diabetic and you know that they need to be on insulin, but you decide to ignore the fact that they need that and just let them go without telling them they need their insulin, that could be considered nonfeasance. All right, and the last part of this video that I want to talk about is the Health Insurance Portability and Accountability Act, or as we better know it, HIPAA. HIPAA is a law that was passed by Congress in 1996. The purpose of HIPAA was to seek improvements on efficiency and effectiveness of the healthcare system through insurance reform and administrative simplifications. Simply what that means is it put all patients to have the right to their personal privacy respected and their medical records handled with confidentiality. What that means is that no information can be told to another person without the consent of the patient. Okay, so a great example, you don't want to walk down the halls of your facility talking about the patient that you had in this morning who had HIV. That's a violation of HIPAA because they did not give you permission to openly talk about that in the main common areas. With HIPAA, it gives more control to the patient over their health information. Medical practices are required to notify patients about the uses, disclosures, and rights of their protected information. So if you've ever gone to a doctor's office, every year they make you sign a HIPAA confidentiality form, and that pretty much explains what will happen with your medical records. Medical assistants, however, must be vigilant about protecting patient information. Making sure that you're, logging out of your computer screens. Don't leave any information up like that. Don't leave your passwords out where somebody could access medical records easily. Don't talk about your patients at your home life or when you're out with your friends later that night. You want to make sure that all of that information is private. HIPAA requires that all medical employees undergo training during orientation, and their training should be organized into 3 parts. They should have privacy regulations training, transaction standards training, and security regulations training. So just like when we talked about it in week 2, we did a little bit of HIPAA when we talked about the bloodborne pathogens. This is another part of it. They were going to have that training that comes at no cost to the employee, but typically will happen within that first 30 days of them being employed. That's pretty much when that HIPAA training should take place. And really, you should be having updated HIPAA training every year because there are things that could potentially have changed within the past year. Alright guys, that is where I am going to stop for the day 1 video. As always, please make sure that you are reading chapter 3 in full so that way you can come to class prepared and ready for all of the activities that will take place this week. If you have any questions or comments, please make sure that you guys reach out to me either via email or phone, and I look forward to seeing all of you day 1 of week 4. Bye guys.